Well, welcome everyone. Thank you for viewing this presentation for the advanced program. And in the step 2.
Frank, I can't see your screen.
Oh, well, okay. Let me start over again. Well, welcome everyone. I hope that you find viewing this presentation helpful in your planning. This is the second of the 2 presentations for the advanced program in our Step 2 program. The essential agenda for this presentation is to, here's our agenda for today. I just want to go over a couple of the program features and just show you the advanced website page. And then we're going to talk about retirement plan beneficiary designations, because this is one of the more complicated and complex aspects of planning, and it's important for you to get an insight into some of the dimensions of what's required for effective beneficiary designation planning for your estate plan. So, of course, we have the Advanced Education Program this year, which has several special education programs. There's also the Personal Planning Update, which is an individual meeting with me, which can be scheduled later this year. We have the First Call program, and of course that's the ability to call up and speak to us with any questions you might have. And if we can answer the question on the basis of our experience, there is no billing. It's just no extra charge. It's part of the Step 2 program. And of course, I want to remind everybody about CareCall, which is the program that allows for the notification of first responders of the people who are important if you're in an accident, so that they can get healthcare proxies and other information for you. And so be sure to go to the website and get registered and make sure that your information at the website is up to date, so that there are no hitches in what might happen in that respect. So today's program is about retirement plan minimum distribution rules and beneficiary designations under the IRS final regulations. The IRS final regulations didn't actually get final until 2008 or 2009, after a bunch of different statutory and regulatory changes. So it's important to understand if your planning was done before, let's say, 2011, it's important to understand what the ins and outs of this are, because you may need to review and revise your beneficiary designations for your planning purposes. And you'll see why as we go along. Now, it's always important to realize that there are important stories that illustrate various different points. And the key stories to master for beneficiary designations are these 3. The school bus story, and the trip to the IRS supermarket, and the hit parade. I'll tell you what the hit parade is in a few minutes, but of course everybody knows the school bus story. But the trip to the IRS supermarket story is the story that talks about the coupon and using the coupon for estate tax purposes, so that an otherwise taxable estate ends up not being taxable. So the final regulations took effect after a whole lot of different statutory and regulatory changes. I'm not going to go through all of these because I'll be talking about them as we go along. But you can see that there have been a whole lot of changes since 1987, and right through from 2001 through 2008 are the important dates for a lot of our clients, because we started the maintenance program in 2001. So just a few highlights of the presentation is that, and of the final regulations, are that they provide favorable mortality tables. In other words, your minimum distributions are determined based on your current life expectancy when you have to start taking them. And the current life expectancy is based on a table that IRS has published. as part of its regulations. And everyone has the same mortality table. There's one exception not particularly applicable here. And so those mortality tables actually go to age 110. And every year, you don't lose 1 year. You actually recalculate your life expectancy every year. So that allows you to minimize your distributions. Remember, minimum distributions are minimum distributions. You can always take out more, but many people try to minimize their distributions during their lifetime because a retirement account is a nice asset to pass on to their beneficiaries. Another major concept is the idea of designated beneficiaries, and I'll go into that in some details. The regulations also allow us to do some post-mortem planning by using the concept of disclaimers, which you may remember is a legal no thank you. They also clarify how the use of trusts can be, how trust can be used in connection with beneficiary designations of retirement accounts. And they also provide for separate shares, which is really important because originally they did not. So there are several obstacles. There are a couple of obstacles that the final regulations give us. And of course, one of them, everyone likes to have lifetime trust protections for their beneficiaries. And one of the things that we want to do is to increase the stretch out, which is minimizing distributions so that the beneficiary of the retirement account can have distributions over a long period of time with an increasing principal balance in the retirement account. And those objectives sometimes run into problems with the final regulations. So we'll focus mostly on IRAs rather than plans at work. In other words, 401k plans, employer plans, etc. But we need to note that plans at work are originally allowed, but were not required to offer favorable life expectancy payouts. In other words, the stretch out was possible with original employer plans. But we have the employers wanted to follow the Brigham Young rule, which is if Brigham Young were a retirement account owner or an account holder and he had 50 to 100 beneficiaries, the employer didn't want to have to track down all of those beneficiaries for the purposes of continuing to administer the account. So what the employers did was said, if you die, the whole value of your account has to either come out in terms of a commercial annuity, which we will distribute to the beneficiary, and it's a qualified annuity, or the account has to be rolled over to an IRA. And there were some restrictions on what could be rolled over to an IRA. So the Brigham Young rule allowed employers to avoid the hassle of trying to find and administer retirement accounts for over long periods of time for beneficiaries who might be scattered all around the country and never had an employment relationship with the company. So there are several distribution methods adopted by the plans. The first, of course, is the Brigham Young rule. And Congress allowed what happened during this period of time with these changes was that Congress gave to the taxpayers certain favorable provisions that were usable with the employer plans. IRS took them away to a certain extent. And of course, so that the Brigham Young rule still ruled. Excuse me, but Congress then gave it back. So the Pension Protection Act of 2006 provides the opportunity for non-spousal IRA rollovers. But it was an opportunity. It just said that they were authorized for plans. And of course, plans didn't have to amend their plans. Companies didn't have to amend their plans. And IRS said that the ability to have a non-spousal IRA rollover from an employer plan could only be done if it was included as an option in the plan. So IRS basically took the whole concept away because most employers weren't going to amend their plans. And then the worker, retiree, and employee Recovery Act, that's 2008 as well, required employer plans to allow a rollover to an IRA. So Congress gave it all back. Now, on retirement account distributions, just remember you know more than you think. You know who owns your IRA account. You know when you have to pay tax, and if it's a traditional IRA, that's when you take the money out. You know that there's a penalty for early distribution, in other words, distributions before 59.5. And you know when you have to withdraw it, which is April 1st of the year following the year in which you are age 70.5. So those are the things that most people know and are fairly familiar with. Also, one thing that people easily forget is that distributions from retirement plans are controlled by the beneficiary designations. They're not controlled by your trust. So just because you have a revocable living trust and we've designated beneficiaries on your retirement accounts, if you die or you become disabled, it's not necessarily controlled by your trust if your beneficiary designation isn't directed towards your trust. So it's all about the beneficiary designation that really controls how retirement accounts are controlled. So why pay distributions to a trust? Well, there are three general school bus type protections. There's the potential creditor protection, which we all are aware of. There's divorce protection, which is a sort of or a kind of school bus protection. So protecting the beneficiary from losing the money that's in the trust in the event of a divorce. And there is potential illness protection, protecting the beneficiary from the loss of funds that are in the trust because they otherwise qualify for Medicaid. And then, of course, here's the hit parade. And the reason that we want long-term trusts for our beneficiaries, or that many people do, is essentially in the hit parade, because if we gave them that money to the child directly, they could hit the school bus, or the school bus could hit them. Their marriage could hit the rocks. The kid could hit the bottle. The kid could hit the books. A kid can hit the lottery, or a kid can hit the skids. That's known as the hit parade. So that's a real life explanation of why long-term trusts are often valuable for the child, because it retains the assets in the trust as a resource when all of those different kinds of things can occur. And of course, for an IRA, you do have some creditor protection, and there was a recent court decision that says that an IRA has the same kinds of protection as ERISA plans up to the amount that's reasonable for the person to need for their retirement. But it doesn't say that distributions from your IRA are protected too. So what creditors can do is just wait for the IRA owner or the beneficiary to take out distributions and then be there to collect them. So one of the reasons why we want to have trusts is because the IRA can make distributions to the trust and they're still unavailable to the creditors. And of course, if one gets divorced, it's easy to trace the source of funds that someone has from a retirement account, and distributions from the IRA often lose their protections, even though if they're in the IRA, typically they're not reachable. And then, of course, there's the catastrophic illness protection. We need to have access to funds. If it's not in the trust, the only way to access the fund is through a power of attorney during our lifetime if we're disabled, or we might have to have a conservator or guardian appointed. And the distributions from the IRA and the balance of the IRA itself can disqualify the IRA beneficiary from Medicaid. As a matter of fact, Medicaid will require IRA principal to be spent down before they will cover a person on Medicaid, which means that the IRA owner ends up with ordinary income, if it's a traditional IRA, throughout the period of the spend down, which can be quite expensive because the Medicaid people don't really think too much about the taxes you have to pay. So that's why we want to provide the school bus protections. Then, of course, there's also the option of the reason for having it is the financial instructions. We want to teach the potential income tax deferral, if that's possible, so that the trustees can also help the beneficiary, particularly if they're young, by teaching them the potential benefits of deferring the income tax over time by not taking the money out of the retirement account, and the ability to control and direct the deferral. So we know that we have to take out minimum distributions during the lifetime of the beneficiary, but we don't have to take out more than we need to, which means we can control how long that deferral goes. Remember, minimums are minimums. There are minimums for you and also for your beneficiaries. More can come out if it's wanted, but it's advantageous often to have the minimums come out if the distributions aren't particularly needed. So we can teach the potential income tax deferral. We can control and direct the deferral itself. We can talk to beneficiaries about investment policy and philosophy. And remember, if the trust is a beneficiary of the retirement account, then the trust is what controls how the retirement account's investments are invested. Because like any other beneficiary, that's how that's controlled. So remember that for death tax planning, this is another benefit, death tax planning is only available or is only possible if we make distributions payable to the trust, because remember, in the trip to the IRS supermarket, the trust is what allows us to use the coupon in a married couple situation. And so death tax planning is also a major benefit of having a retirement account payable to the trust. So let me give you a 10-minute technical review on the distribution rules. It's just 3 things to remember. It's really easy as blue, yellow, green. True blue means that you have a uniform table for withdrawals during your lifetime, and you continue to withdraw your minimum distributions when that's appropriate. But if you name your trust as a beneficiary, you have to take a test to determine how fast the distributions are required. And if you pass the test, then you get a green light, and the beneficiary continues to get distributions for their life expectancy. But it's the test that's important. So what happens if you don't meet the test? Well, the first is if you die before if after you've started taking distributions of your retirement account funds at age 70 and a half, then we don't get to use anybody else's life expectancy. We have to use yours for the rest of the distributions. And if you died before you started taking out distributions from your retirement account, we have to use the 5-year rule, which is that all of the distributions, the entire account has to come out in distributions over a period of 5 calendar years. So to get the income tax deferral we want, and at the same time get all the personal protections and the personal instructions and the death tax planning, we have to pass the test. So it's the same test whether you die before or after your distributions begin. And remember, if you die before, it's the 5-year rule, and after, it's your life expectancy. Those are not advantageous payout regimes. And so as with any test, there are 3 things you have to do. You have to know the material, and you do that by studying. You might get a tutor, and you might do both. And this is one of the reasons we have the Step 2 program, so that people who are beneficiaries can understand how all this works, because it can be fairly complicated, and it's very easy to make a mistake and lose the benefits of the retirement accounts. The second, of course, is you have to show your work. If you're in school, you have to show your work. And, of course, you have to turn it in on time. And if you do all 3 of those and you do a good job on your work, you'll get an A, hopefully. So to assure the distributions are based on the favorable life expectancy, we have to do one particular thing. We have to name a designated beneficiary. Now, a designated beneficiary is a term of art. It's something that's defined in the regulations. Excuse me. And it's a fairly complicated definition in the regulations, but what it boils down to is what we call the heartbeat test. If the beneficiary has a heartbeat, then that person can be a designated beneficiary. In other words, the designated beneficiary has to be an individual human being. But if the beneficiary doesn't have a heartbeat, then the beneficiary doesn't qualify as a designated beneficiary, and the result of that is that we get those unfavorable distribution regimes. So as far as IRS is concerned, here's what the heartbeat test means for trusts. It allows distributions based on the life expectancy of the beneficiary. It's easy when the beneficiary is important, but we have to pass a 5-part test if the trust is a beneficiary. And in order to get the heartbeat, we have to be able to look through the trust. We have to pass this test, so that we want to use the heartbeat or the life expectancy of the youngest beneficiary, so that we can use that stretch out over their life expectancy. So here's the test. And if you don't pass this test, the trust does not qualify as a designated beneficiary. So several of them are fairly easy to pass. We have to have valid, it has to be valid under state law. It has to have individual beneficiaries. The beneficiaries have to be identifiable. The trust has to be delivered to the administrator on time. And the trust has to be irrevocable on death. So, numbers 1 and 4 and 5, numbers 1 and 5 actually are almost automatic with us. Number 4 is a timing issue. It has to be delivered in a certain period of time to the plan administrator. And it's numbers 2 and 3 that can trip people up. So if the trust qualifies, it's invisible. So the beneficiaries are designated. All the beneficiaries of the trust are designated, and we can look through the trust to use the heartbeat of one of the beneficiaries. So common mistakes that happen, though, are we can name a non-designated beneficiary. That's a no-heart problem. Or we can name the wrong designated beneficiary. In other words, we can end up with the oldest possible beneficiary, and that's a bad heart problem. And if we have multiple beneficiaries in the trust, we may end up having to use the oldest heart, the oldest beneficiary's life expectancy. And that can be important if the beneficiaries vary widely in age. There could be 10 or 15 years difference between beneficiaries in the trust, and that can have major disadvantages for the youngest beneficiaries if they have to take out minimum distributions based on the oldest beneficiary's life expectancy. So we have this toolkit that we use typically in terms of post-death planning in order to be able to pass the test. There's the distribution strategy, disclaimer strategy, and division strategy. So passing the trust test means for when we have no heartbeat is the distribution strategy. For the bad heart, we have the disclaimer strategy, and for the oldest heart, we have the division strategy. So how does that work? The distribution strategy essentially works when one of the beneficiaries of the trust is a charity. If we have several individual beneficiaries, but one of the beneficiaries of the trust is a charity, we end up with an institution as the beneficiary, and they do not qualify as a designated beneficiary. The charity does not have a heart, technically. Of course, lots of charities have are the result of people having a heart, but that's not what we're talking about. Charities are not qualified designated beneficiaries. And so that means that we have to begin distribute. The way that what we do with a charity, if we have it in the trust, is we want to distribute out to the charity what they would be entitled to prior to September 30th of the year following the date of death. So we do that so that by September 30th of the year following the date of death, the trust no longer has a non-designated beneficiary. The charity is gone. And we have to designate who the beneficiary is on or before September 30th of the year following the year of death. Now, if we have a bad heart problem, so if we have a trust and the beneficiary is an older person, then we can have the trust disclaim to a surviving spouse. And then the surviving spouse can disclaim all or a portion of the IRA to individuals. That's what we can do if we have a bad heart obstacle. So, and that may be possible or required in some states where the beneficiary designation, or some trusts where the beneficiary designation doesn't quite work out the way we want it to when we're taking a look at the settlement of an estate. And then the division strategy is, it's used to avoid the oldest heart obstacle. What we do is we divide the IRA into separate shares so that each beneficiary has their own separate IRA, so to speak. And then the separate shares for the IRA end up having their own beneficiary designation, their own qualified beneficiary, and so the individual beneficiaries who have their own separate share can have their minimum distributions over their own life expectancy rather than that of the oldest beneficiary. And one other strategy is to set up a separate standalone trust that's there as a receptacle for the IRA, waiting for it to become an IRA receptacle, and we can use that for each individual beneficiary. And there may be some reasons why we want to do that. Now, the IRS issued some private letter rulings in 2005 that allowed the division of IRAs after death. And before that, we just didn't know whether they could be divided after death. And then payment is allowed also directly to subtrusts if we use individual, and we can use the individual life expectancy under that subtrust. So that's the division strategy. So disclaimers and division strategies require customary beneficiary designation planning. So what are the obstacles to this? We have the protections versus the amount to be distributed, and we have the protections versus the tax on the distributions. Because remember, if we have to make distributions and we have to make more than we want to, somebody has to pay income tax on those distributions unless it's a Roth. So here's the test again. What IRS did was they came out with the final regulations, and their primary concern was the third prong. In other words, how do we identify who the beneficiary is? And that raises questions about powers of appointment and the potential use of distributions for reasons other than for the benefit of an individual beneficiary are also potential problems that IRS is trying to address with the regulations. So if we want to drive our decisions based on protections, instructions, and each individual beneficiary life expectancy being used for the determination of distributions, what do we do? Well, when would you not want these protections for the beneficiaries? Well, I'm going to leave that question by itself. And that's why so many choose to have a protective lifetime trust designed for their beneficiaries. So a retirement wealth reception trust is something that was developed in the early 2000s to deal with some of the unknowns that we had and that have now been clarified. So the key question for the IRS is what happens to the money in the lifetime trust when your beneficiary dies? If we know who the living beneficiary is, that's fine, but what happens after the beneficiary dies? If the money can be used to pay taxes, that's a problem. If the money could possibly go to a person who has a longer life expectancy, that's a problem. I'm sorry, a shorter life expectancy than the beneficiary, then that's a problem. If they're going to pick a life expectancy, they always want to know that it's going to go to people who have longer life expectancies than shorter, because otherwise the minimum distribution rules are being circumvented. So here's the problem. Most clients give beneficiaries a general power of appointment. And that's a general power is a power that allows the beneficiary to designate who receives the trust on their death, and it could go to their creditors, to their estate, or the creditors of their estate, or anybody else in the world. That's a general power of appointment. So that means that the beneficiary passes the estate through either their will or their trust. That's what a general power of appointment does. So IRS now says the beneficiary isn't identifiable because we don't know who the beneficiary is going to be after the beneficiary dies if they have a general power of appointment. You don't know who that will be. Who's going to get the money? So if we have a general power of appointment, IRS says we fail the test if an unidentified older heart or a charity or some institution without a heart could receive the money at some point. And we also fail to test if it could be used for any other purpose besides distributions to individuals, like paying taxes or claims. So we want to pass the test. That means that we have to deal with, how do we deal with the power of attorney, a power of appointment? Well, there are three approaches to that. One is to use what's called a conduit trust. And what that does is it says that we have, and this is allowed by IRS, it says we have to pay out all the distributions whenever they come out. So in other words, if we have minimum distributions, if the trust requires that the minimum distributions be distributed to the beneficiary, that's okay as far as IRS is concerned. Then we can add special trust drafting instructions so that to the regular living trust, so that we can allow the distributions to stay inside the trust even though the minimum distributions have come out. And we can create individual standalone retirement wealth reception trusts for each beneficiary. So there's three different approaches. So approach number one, it requires outright distributions to the individual beneficiaries. So, and it's based on the oldest heart life expectancy, whoever the oldest heart is in the trust. If the trust has several different beneficiaries, it's the oldest beneficiary, their life expectancy that's going to be used, because that's the shorter period of time over which distributions can be made. So we have to use the oldest heart. There are therefore no personal protections on the distributions. It's just like the person had the IRA themselves and received the distributions when they have to go to creditors, if there are any. We can control the investments and distributions of the rest of the IRA, but not what has to be distributed out. And the assets inside the inherited IRA can be protected until they're distributed out. So that's the conduit. In other words, the trust ends up simply being a conduit for the minimum distributions, or whatever is distributed out from the IRA. Approach number two, paying to a revocable living trust or a regular living trust. What we do is we add special language to address the heartbeat test. So we restrict the use of the power of appointment so that it can't go, a power of appointment can't be exercised in favor of an older heart, and prohibit the use of the money in an IRA, that's where the trust is a beneficiary, for claims and taxes. And in order to be able to watch, to make sure things are going along all right, we can add trust protector language, and of course we have been doing that for some time, to monitor the changes to the law and the legal environment, to make sure that changes can be made in the trust over time, to make sure that the purposes of having the trust as a beneficiary, designated beneficiary, are maintained and remain being being enforced. So approach number three is to create a standalone retirement wealth reception trust, and we can create separate unfunded standalone trusts, and these would be revocable trusts, but there's just nothing in them, and they become the distribution beneficiaries once the person dies. So they can be designed for one individual, or they can be designed for multiple individuals, multiple beneficiaries, but it's very clear and easy for a standalone trust to avoid a lot of the hazards, like distributions being used for taxes or being sent to beneficiaries who don't pass the test. So approaches numbers 2 and 3 were simplified by that 2005 private letter ruling, because it allows us to name subtrusts on the beneficiary form at the financial institution and use individual beneficiaries' life expectancies for those subtrusts. So, and we still might have reasons to use a standalone trust, and we're continuing to monitor that. But one of the primary purposes of the standalone trust was we didn't know that we could have separate shares until 2005. So now we know we can have separate shares, and we know therefore that we can divide the retirement account up into separate shares and distribute those separate shares to the separate subtrusts for the beneficiaries. So what are the trust beneficiaries concerned? Well, a lot of times the beneficiaries don't know about the paperwork. Remember, you have to show your work. So a copy of the trust has to go to the plan administrator so that they can see who the beneficiary is. And the deadline for doing that is October 31st of the year after the IRA account owner's death. So that a copy of the trust has to go to the plan administrator, whether it's an IRA or an ERISA plan. It has to go to the plan administrator on or before October 31st of the year after the IRA owner's death. So then there's rollover concerns. One of the serious problems, of course, is that the beneficiary, if the beneficiary is named individually, and then someone dies, the next thing that can happen is they get a telephone call from a financial advisor or someone who's a custodian of the retirement account, and they'll get the following question. I have a retirement account of X several $100,000. What do you want me to do with the money? And of course the response is going to be, without too much thought, send me the money. And what that ends up being is that the beneficiary accepts the benefits, and they have a distribution, and they no longer have the ability to get the stretch out. And there are some other benefits for a surviving spouse that also are useful over time. But if the surviving spouse receives distributions from the retirement account, we no longer have several options in terms of how we're going to deal with the disclaimer strategy. So we can lose the hit parade flexibility to protect the beneficiaries, and we might lose the death tax withholding and settlement complexity, and cause some serious settlement complexity. So why do we want to roll over? We want to roll over the IRA to the trust because, again, we might need to use the IRA as part of the coupon for tax purposes. And the better tax deferral, of course, is at the children's ages. And so if there's a spouse, surviving spouse, what we want to do is we want to use the coupon, and we may want to use the coupon to fill up some of the coupon trust, the family trust, but the rest of it's not required. So if we are able to have the surviving spouse have the money by disclaimer from the trust and then disclaim again, so that the partially disclaim it, so that part of it goes to the children's with the lowest ages and part of it's used for the coupon, then that is a good strategy. And of course, in qualified plans, they usually don't provide for life expectancy distributions, so we want to roll over the retirement account that's in the qualified plan to an IRA. And if we don't do that properly, we end up with lump sum distributions, or at best the 5-year distribution strategy, or the use of the Brigham-Young rule. So for qualified plans, of course, many people are concerned about, well, what about the estate taxes that are going to have to be paid on that money? And one of the basic strategies to take care of that is to consider life insurance to cover the potential death taxes that are payable on the retirement account as an asset of the taxable estate. And if we're uninsurable, then we might want to use the money to pay some taxes, and that might destroy some of the problems, destroy some of the benefits. So if there's, but what we want to do is make sure that the taxes are paid from non-retirement funds. So if we're uninsurable, we want to provide that when the trust is being settled, that the trustees know that they have to use non-retirement account funds first. And if there's no surviving spouse and we have a non-spouse beneficiary, we can now roll the account over to an inherited IRA for that beneficiary, even though they're not a spouse. So, and that's important. So, what are the hazards? Well, some of the hazards relate to coordination between attorneys and accountants and financial advisors. And during the lifetime, what we find sometimes is when the clients aren't really paying attention, they might move their retirement account from one custodian to another. And the result of that is that they undo their beneficiary designations that they had when they did their original funding. And the result of that is that the default rule in retirement accounts, IRAs in particular, is that if there's no designated beneficiary, or no beneficiary designation, it ends up going to the estate, and then we end up with that 5-year rule. So what happens oftentimes is that financial advisors are concerned about using the 5-year rule. They're not aware of whether the trust can be used as a see-through trust for beneficiary designation purposes, and if it can't, they end up, the trust beneficiary ends up with the 5-year rule, and the advisors typically try to avoid beneficiary designations to trusts because of that concern until they're informed of the specifics of that trust. And so there can also be uncoordinated rollover efforts after someone dies, so that the IRA is rolled over, but it's not, some of the options that are available are not considered, and a disadvantageous rollover or a long-term distribution result can occur. And of course, the planning partner concerns are, typically we don't, unless we know each other, we don't trust, and it's typical that advisors don't talk to each other, and it's the client's role to end up making things happen. And what we think is that it's also our role. So we want to have relationships with your advisors, and we'll be talking to you about that at the annual client meeting. But we want to make sure that the advisors who are part of your team for estate settlement purposes are fully informed of what we're doing, what the results of your trust is going to look like, and so that everything goes smoothly for you and your family. So, again, we talked about the wealth reception obstacles, protections versus the amounts distributed, and for protections versus the tax on the distributions, which is something that we can cover later. Because remember, when you make distributions to a trust, if the distributions are not distributed out to the beneficiary, they stay in the trust, and the trust has taxable income. And the trust reaches the highest taxable bracket, including the 3.8% Medicaid tax, or Medicare tax, when the trust reaches $12,100, the Medicaid tax at $12,150. So the taxable level is a little bit more for other income tax purposes, but that's a very small amount until you get to the highest bracket. So it's often advantageous to distribute money out to the individual beneficiary, because that means the trust gets a deduction for that distribution. But if we distribute it out, we lose the protections. It would be nice if there was a strategy that we could have where we didn't have to distribute it out, but we still got the tax bracket of the beneficiary. And that's something that we can discuss later, but it's not part of our topic today. So the beneficiaries, protections for the beneficiary when they receive the distributions are much higher if they're retained in the trust, and a lot lower if they're paid out to the individual. And the tax rate to the beneficiaries is higher if retained in the trust, and lower if paid out to the individual, typically, unless the individual has a very high income, in which case it doesn't matter whether it goes out to the beneficiary or not. Of course, the risk is that the beneficiaries will take out the distributions to save current income tax, but when they do, they lose the protections. So how can we get both the protections and the distributions taxed at the lower individual rates? Well, that's the topic of a longer conversation, but I will give you a hint. It's the same strategy that we use when we make gifts to insurance trusts and don't have those gifts to the trust be taxable for gift tax purposes. So I'll give you that as a hint, and we can certainly talk about that at another occasion. So what's the next step? What we would like to do is to make sure that you go to your annual client meeting, because in the materials that you're going to be receiving at the annual client meeting, there will be a checklist of options that you might have, and there will also be some recommendations in the EPRW that we will give you this year, so that even if you're not updating this year, we're going to give you an EPRW that makes suggestions about how your beneficiary designations might change. And so take a look at that. We're going to be providing a checklist for you to check certain options off. And if we think that the checklist isn't quite going to work for you, we'll let you know and suggest that you come and talk to us individually for a consultation. So I want to thank you very, very much. Please be sure to go to the your annual client meeting. Be sure to register. If you're not able to make either one, we're considering setting up some a special annual client meeting. It might even be done by webinar online, but we are thinking of setting one up because we've had a few people who've indicated that it's very difficult for them to get to the dates that we've scheduled for annual client meetings. So please let us know, and we hope very much to be seeing you later this spring. So thank you very much for attending, and I look forward to hearing from you with any questions you might have.